Bright Tuty. Every student matters.
Now, after that we are going to take the another topic, that is topic 5.5, statehood and special provision in the Constitution of India. So, here we are going to talk about that how statehood has played an important role in Nagaland and what are the different special provisions in the Constitution of India, especially related to the northeastern state, that is related to Nagaland also. The political history of Nagaland and the present political situation of Nagaland are extremely complex one. Here the two aspects are examined, namely the statehood and the special provision in the Constitution of India for Nagaland. So here we are going to discuss about the statehood first. At the time of India's independence, if we discuss, Nagaland was a district in the state of Assam only. It was a part of Assam. Leaders of various Naga tribes were not satisfied with this situation. Therefore, what they asked, they started demanding for the formation of the separate state. They formed the Naga People's Convention, that was NPC, August 1957, after 10 years of independence. At its first session, under the presidentship of Dr. Imkong Liba, the NPC proposed the formation of new administrative unit merging the Yongsan division of NEFA, that was Northeast Frontier Agency, with Naga Hills district. So this initiative was taken. During that time, the government of India agreed to the proposal, and on 1st December 1957, the new administrative unit known as the Naga Hills and Yongsan area, that was NHTA, was also inaugurated. And in July 1960, a delegation of NPC, they met the then Prime Minister of India, Jawaharlal Nehru, and a 16-point agreement was arrived at, where the decision was taken to make separate area out of Assam, and that was going to be called as Nagaland. As a result, the state of Nagaland within the Indian Union was created, and on 18th Feb 1961, an interim body of 42 members was constituted to function as the de facto legislature. In 1962, the Parliament passed the State of Nagaland Act 1962 for the formation of Nagaland as a full-fledged state. Means this was not a very short process. Since after independence, if we talk about, things were going on, and slowly and gradually the demand and the protest by the different groups resulted in the full-fledged formation of Nagaland as a state. Consequently, Nagaland as the 16th state in the Union was inaugurated on 1st December 1963. So, if we talk about what was the number of this state in Indian Union, so that was 16th, and we need to remember the date also, that when it was adopted as a state, that was 1st December 1963. There are different views about the effects of statehood. According to one view, statehood has brought electoral politics to Nagaland. Because of this electoral politics to Nagaland, it resulted in the introduction of some undesirable aspects of the Indian electoral politics. Besides that, statehood also has meant the introduction of the local bodies. It brought a considerable amount of fund to Nagaland, because now Nagaland was a separate state. So, they started getting the separate fund for that. The presence of easy money and electoral politics is considered to be the root cause of widespread corruption in Nagaland. So, on the other hand, we can say, although the negative points were there, that how the corruption was prevailing in the society as Nagaland emerged as the statehood. But because of that statehood only, it was made possible for Nagaland to enter the modern world, and then it was exposed to modernization. This was a time when it was able to move towards the development or the growth. The constitutional provision we'll discuss here, that what was the amendment done. The constitution, that was the 13th Amendment Act, enacted at the time of giving a statehood to Nagaland, means to give that status to Nagaland, it was not easy, and the changes were brought, or the amendments were done in the Nagaland, and the amendments were done in the constitution. It inserted Article 371A into the Constitution of India. This new article was added. This article has a special provision only for Nagaland as a state. Among other things, Article 371A has laid down that unless the Legislative Assembly of Nagaland so decide, no act of the Indian Parliament will apply to the state of Nagaland in respect of the following point. So, this was one of the special provision of Nagaland. Here we can discuss, and what were the points that they had the power to decide over: religious and social practices of Nagaland, Naga customary law and procedure, administration of civil and criminal justice involving the decisions according to Naga customary law, and ownership and transfer of land and its resources. So, these were the things which were decided that no other act of the Indian Parliament will apply to the state of Nagaland until and unless the permission is not given by this Legislative Assembly of Nagaland. These constitutional provisions of Nagaland are unique. Why these are unique or different from the other? Because such provisions are not made in favor of any other state or the community. These are separately given to Nagaland only. They give complete autonomy to the state of Nagaland in social and the religious matter, and protect Naga traditional law as well. So, this is one of the distinctive feature of Nagaland society. We can say that Nagaland state, we can say, where they have proper right to protect their own Naga traditional laws.